Hello, welcome to Legal Learning. My name is Bertha Santana with Coast to Coast Legal Aid. Today we will discuss parenting plans. A parenting plan is required in all cases involving time sharing with the minor children, even when time sharing is not in dispute. It can either be agreed to by the parents and then approved by the court, or if it cannot be agreed to by the parents, then a parenting plan will be established by the court. There are 3 different parenting plans designed by the Florida Supreme Court, which are available for you to use or review at www.floridacourts.org. And the 3 are at the bottom. Parenting plan, which is the standard one. It is common in most paternity and dissolution of marriage cases or any case involving time sharing with the minor children. Then you have supervised / safety focused, which is basically a parenting plan that you will use if it is in the best interest of the minor child for one parent to have supervised visitation. The other one will be relocation / long distance, which is a parenting plan, just as it's titled. It's one where one parent may be living miles away from another parent or maybe in another state. And at that point, the parenting plan is focused in a long distance way to allow time to be shared between both parents, even though they are miles apart. Now, Florida law does not use the term custody anymore. It has now been divided into parental responsibility and time sharing. And parental responsibility under Florida law just basically means who has the power to make decisions for the child. And you can see a more legal definition in Florida Statute 6113. And here on the other side, this is copy and pasted from a parenting plan. This is how you will choose which parental responsibility in your parenting plan you believe is in the best interest of the minor child and good for your family as a whole. There's shared parental responsibility, which means, it's in the best interest of the minor children that the parent confer and discuss all major decisions affecting the welfare of the child. And that's not limited to education, minor child's healthcare. And then you have shared parental responsibility with decision-making authority, which is almost the same as the first one. But in this case, one parent will have decision-making authority when both parents cannot confer and decide on the major issues. And then we have sole parental responsibility. And as it states, it is in the best interest of the minor child that the parent, depending on which parent it will be, will have sole authority to make major decisions over the minor child. And you would have to show it's detrimental at this point that the child have shared, parental responsibility. It's not in the best interest of the minor child. And now Florida law no longer uses the term visitation. We now use the term time sharing. And the parenting plan at a minimum has to address how both parents will share time with the minor child. And this is copy and pasted from the parenting plan. As you can see here, there's weekday and weekend schedule. You'll have to tell the court in your proposal, or if it's agreed by the parties, when this time sharing schedule is going to begin. And it's detailed as to, what weekends parent X will have versus what parent Y will have, what weekdays, and from what time to what time on these dates. It's very detailed plan. And the time sharing is not just only on weekends. The time sharing schedule in a parenting plan also discusses holiday schedule, winter and summer, spring break, summer break. These are all detailed. And sometimes they're based off the school calendar, depending on the minor child attending school. And it may help even with parents in a long distance. This terms in the parenting plan may help them provide them more time since they can't be with the minor child maybe all the time on weekdays or weekends. Maybe summer, winter break, or spring break is the time the other parent can spend more time with the minor child. The best interests of the children always the primary consideration in creating the parenting plan. All circumstances between the parents, including their historic relationship, domestic violence, and other factors must be taken into consideration. Determination of the best interest of the children shall be made by all the factors, and the factors are in 6113 Florida statute. But it'll be made by evaluating all the factors affecting the welfare and interests of the particular minor child and the circumstances of this family. And as children age, it's good to respect their natural desire to spend more time with one parent over the other. 6113 also states, the court can take into consideration, depending on the maturity of the child, What is their natural desire? What is their opinion on which parent they desire to spend more time with or not? Now, trying to limit the other parent's parenting time can have long-term negative effects on the minor children. The last things to consider when drafting a parenting plan or reviewing it is don't focus on numbers like 50-50 or equal time sharing. You need to focus on what is best for the minor children and what works for your family as a whole. The parenting plan is a very detailed plan. It's extensive. You need to be as detailed as you can be if you're proposing this to the court or it's a parenting plan that both parents are agreeing to. The parenting plan will go into communication with the minor child, travel, foreign travel, in-state travel. It's very detailed. And also the last thing to consider is these parenting plans need to be something that not just works now, but it needs to work for years to come until the child becomes an adult. And it's very easy when drafting a parenting plan to see that the minor child is 3 years old now and not, consider extracurricular activities or what will happen with foreign and in-state travel. But this parenting plan needs to be something that not just works when the child is 3, but when the child starts school and ends school and when they graduate and become 18. So this is a parenting plan that is detailed. It needs to be one that when you draft, not only considers what has happened presently, but what can happen in the future. Thank you for watching, and tune in Thursdays at noon for more legal learning. Join us next week for Unemployment with Michael. Please like and follow us on Facebook and YouTube at Coast to Coast Legal Aid.